In this video, we're going to take a look at legislation for creative iMedia. So first things first, as usual, the units. So there has been questions in the past. We're actually going to cover a question later on in this video about copyright, which is a past paper question. So there's going to be some questions on there. It's good to have knowledge. Even in real life, it's just good for understanding just a general life to understand copyright and things, especially if you're creating lots of content, if you're going to be a YouTuber or something like that. And in all the coursework units, there's always a strand in the mark scheme for having a good understanding of ethical or legal restraints. So the kind of definitions of words you need to really know for the exam and for your coursework is intellectual property, copyright, trademarks, Creative Commons, royalty free, and Data Protection Act. Although I will cover a couple more as well. So intellectual property. So this is where you describe something that has been created by somebody. The idea is that you can't use somebody else's intellectual property without permission. So if someone's written a book, you can't copy it. If someone's written a film and then filmed it, you can't copy it. Movies, games, apps. Despite you seeing lots and lots of, especially on these like silly adverts on various free games on Android and Apple, and you see lots of games that look very similar to each other. Really, this is fairly clear cut when it comes to using someone else's intellectual property, although depending on the company, if you've even remotely copied something, they may take you to court. Then you've got copyright, which is a law that protects someone's work that they've created. So as soon as you've completed that piece of work, you've got the copyright for that. I mean, it's a little bit difficult when you think about things in the past. If you've created something, how do you prove you created it before them? That's the main thing. But if you can prove when you made it and you can prove it was before somebody else, that's when you can win in court or whatever. So if you wish to use something that someone's copyrighted, first things first, you need to contact the person who made it. Then you ask permission if you can use it, and you may have to potentially pay a fee. Now, those bullet points here were actually a past paper a few years ago where it said, you want to use an image from this website, what should you do? And the answer was, contact the owner, ask permission, potentially pay a fee. Now, you don't have to worry about this too much for your coursework in school. You can use pictures and things like that and get away with it. However, if you just keep writing, I can use this picture because it's for educational uses, then you're not going to get that high understanding. So really, in your coursework, if you can explain, what copyright is, how it's relevant, what laws you breach, things like that, just show a good understanding, that's where you get those marks. Source in them, but what you don't have to do is go and ask the owner for permission. That's absolutely fine. One thing you could do though is use copyright-free images or royalty-free images or websites like Unsplash, where you can use the pictures as long as you credit the user, credit the author, sorry. If you use that, then and explain why you've done that and copy the license agreement, then you're showing a high level of understanding and you're still sort of working quite quickly and just getting images off one website and things like that. And you've got trademarks, which can be a name, a word, a slogan, design, a symbol, or something unique that identifies a product or an organization. So usually you can see they've got a TM or an R symbol. And again, if you want to use something that's trademarked, you can have to contact the owner, ask permission, and then when you do use that, you can have to use a TM symbol along with the image, and then make sure that you're fully acknowledged and said that you've got permission from the owner. More likely than not, if it's a big company, they're not going to let you use their trademark. I think it was a recent thing where I think it was Hugo Boss have trademarked boss, the word boss, even though it's just a normal word. If you use it in a product, then they can take you to court kind of thing. So that's why if you've ever watched Joe Lycett's Got Your Back, he changed his name to Hugo Boss because I think it was a brewery called a really small brewery called their product Boss Brew or Brew Boss. I think it was Boss Brew, and then they were told they had to change their name because of that, despite Boss just being a normal word. Next, we've got Creative Commons. Now, there's lots of types of Creative Commons license. So here's a couple on the screen, but this is a special agreement where the person who creates the content allows their resource to be used. So you've got attribution license, where people can copy it, modify it, change it, distribute it, display it, but you must say, right, original image was made by whoever. Then you've got non-commercial, which you can do basically whatever you want with it, but you can't make any money from it. And you've got no derivative works, so you can copy it, you can distribute it, display it, but you can change it. And then you've got share alike, which can be modified and distributed, but must be covered by the same license. So you can take somebody else's share alike image, change it, make it your own thing, and then say, right, you've got to give me money for it. You've got to use the same license. There's just a couple. And then you've got copyright free and royalty free. So copyright free is where the work is not protected necessarily by copyright, but a fee still might have to be paid to obtain it, but your use is not restricted. And then you've got royalty free, where you pay usually a one-time fee and you can use a piece of work that's copyrighted, but it's not copyright free. So quite often you get royalty free music. So you've got websites like bensound.com, for example, has lots and lots of sound musics. So what you can do is you can pay like £4, I think it's something like that, for the track, and you can use that on whatever you want, or you can pay like a more expensive license, which means you can use any of his music on your videos. You also need to know about the Data Protection Act, which at the minute it's superseded by GDPR, but as far as I'm aware, at this moment in time, you don't need to know GDPR over data protection for the exam, but it's good to have an understanding of it anyway. So the Data Protection Act is a law which protects people's information. It's a set of rules for people who store information to follow. So if you host a website, or you're doing a survey or anything like that, and you're storing information on people, you need to follow these rules, and it protects people's rights. So people who use that data are called data users, and the people who provide the information are called data providers. Now, if you want to look into more detail on GDPR, there's a website link on the screen right now if you want to go onto that, read a few of the laws. Now with Brexit, I'm not too sure how it works for United Kingdom specifically now, because I presume they will take their own version of GDPR, but I'm not a politician, I don't know. But if you're using anything that's in the EU, you will have to follow GDPR still anyway. So the main principles, there's 8 principles, I'm going to put them on the screen here. You do need to have a rough understanding, but you're not going to get asked to, or you shouldn't, as far as I'm aware, get asked to recite 8 of the principles in an exam question. But if you collect data about people for one reason, you must not use it for a different reason. So for example, I created an app, which you can't download it because I never finished it, which was like a fitness app, and it gathered information on like your name, your Facebook email address, because it had like a scoreboard system on Facebook, and your gender and your height and weight, because it's for fitness. So I used it for the app. I couldn't then take that database full of data and use it for another app. I'm not allowed to do that. You must not give people's data to other people or organisations unless they agree, so that stops people from selling people's data. People must have the right to look at any data, so you can ring up or you can contact a company and say, right, you've got this information on me, I want it. You can't keep the data for longer than you need to, and it needs to be kept up to date. You must not send the data to places outside of the European Economic Area unless there's adequate levels of protection, so it's encrypted and things like that. Organisations that store data about people must register with the Information Commissioner's Office. If you store data about people, you must make sure that it's secure and well protected, and if an organisation has data about you that's wrong, you've got a right to ask them to change it. Now, 2 more laws I want to talk about. One more with 2 things, which is defamation. So this is where you make a spoken or written expression which is deemed to harm the reputation of an individual and proved to be false. So it's not saying something like, so-and-so's done this and they have done it, and it makes them look bad. It's if you make up things or you say some things that are false, which makes somebody else look bad. So there's 2 different types for defamation. You've got libel, which relates to creating a statement, such as in writing, or TV, or something where people can get access to. So if you put something on Twitter or on TV, then it counts as libel. And then slander is sort of usually like you'll do a speech, or you maybe say something on the radio or something like that, where you're saying something negative about somebody that is false. And last thing I want to talk about, which may or may not be relevant to your coursework depending on the briefs, if they change. If you're doing something like to do with film and TV, then this comes into play. So you've got the British Board of Film Classification, and these are responsible for any censorship, any national classification, mainly TV shows and films. And you've got things like Universal, PG, 12A. So if you go onto their website, bbfc.co.uk, you can check out a bit more information, but having a rough understanding of the different classifications is really useful for your coursework. But most countries have some form of classification like this. So if you ever flown on a Qatar flight, for example, a lot of their films, they take out all the swearing and in some cases violence as well. So for example, I watched Deadpool on a flight with Qatar Airways, and they blocked out every single swear word. So it sounded a little bit weird, some things didn't make sense. They often replace them with words that sound similar. And yeah, it's sort of ruins the film a little bit, but it's a way of sort of getting around certification and classification. Now, there are 2 quizzes I've got on screen now if you want to do them. Not necessarily created by myself, but on legislation and general media ones, so it's something that you want to maybe play with your friends, something like that you could use. And thank you for watching. That's legislation. That's going to be the last video on actual theory in this main set, so the very last lesson. But there will be other videos supporting various pieces of coursework, technical skills, how to use pieces of software, and exam skills. But thank you for watching the video. Please, if you haven't already, watch the other videos, and I will see you in the next video on the channel.